I guess we are. Can you hear me clearly? Can you please confirm?
Yes,
Yes,
sir.
sir, you are audible.
Okay, perfect. And one more thing, my screen is visible. Is that also visible now? My screen is visible to all?
Yes, sir.
Yes, sir, very well.
Okay, perfect. So, okay, I'll keep it here. We have enough time, luckily. Some recent judgments we will be discussing today. Many of we are here now. We have CAs, CS. How many of us are advocates here? Or mostly CAs and CS? Before we start, don't worry, we have 3 hours to go. Okay, so, and not many cases because I believe, uh, knowing the process is more important than just mucking up the name of the case, which will not make a much difference to anyone's life. And in the era of, I believe in the era of uh, AI, you don't need to remember anything actually. You just put a small comment and it will provide you name of the case. What you, I believe, what you actually need to know is how the process is about to run. Now, since we are already, in the 8th year, and I can see, most of you are must be senior to me also uh, in this field. Uh, I have been doing it from 2018. So, and have since we have been appearing at different NCLTs, NCLAPs, we we do come across that, if you are advocate IP, then it is still fine. But when it comes to CA, CS IPs, uh, NCLTs are taking very harsh decisions these days against the RPs, even for smallest of problems. So, in my view, even if you don't remember the name of the case, just do know what is happening. Okay, do know what is happening in this field. Uh, what you are supposed to avoid, what you are not supposed to avoid. Though most of us knows what we are supposed to avoid, uh, but knowing our business is important. So during my presentation, I think we have around 65 slides or something. So 9 cases we will discuss today. Out of these 9 cases, one, two, all of us must be aware of them. We will do a discussion on them. Discussion in the sense, uh, please feel free to disturb me in between. I don't get disturbed. Okay, so please stop me, give your input. What you think is whether it's correct or also or not. Like, just to give you an example, recently in one of the 138 matter, where the check bounce case, right? Few days back, Supreme Court has said that no, it should be presented at the place of where at the issuing bank. I mean, so far people were, the jurisdiction was of where the check is presented. You can give it to that court also, correct? Since you are CAs, I guess you are aware of that. So please feel free to talk because otherwise it will be a one-way communication and then the PPTs are thousands in the world. So if anyone is aware, just let me know. We can do some discussion. So 138, which is check bouncing, now Supreme Court is saying that it should be done at the place of issuing of the check. Uh, my personal view, I think it's not a great decision. I feel it should be. Actually, both the places should be allowed. The name of the where it was issued, as well as where it was presented. That's my view. So maybe somebody else can have their own view. Same way, when we are discussing about these 9 cases, if you have your own views, please do come forward. We will talk about it. Otherwise, what is settled in the law, that I will at least tell you for sure. So today we will be doing the CIRP cases, not the PIRP. PIRP will take up tomorrow, which is Anil Sayals, Anil Kumar, etc. All those cases we will do tomorrow. Today we will focus on the CIRP cases. I hope that's fine with everyone, right? No? Okay. No one is talking.
Not a
Only
problem.
CPRs, huh?
You continue. You
Okay.
continue.
Okay. So, fair enough. We have 23 participants. I hope more will join. So this is about me. Next one is, so first case, which is most famous case right now going on, Kalyani Transco Private Limited versus Bhushan Power and Steel, right? Where I hope there is no one here who doesn't know about this case, right? We are aware. So on 2nd of May, Hema Kohli ji, she, ma'am has given this judgment. Now, this is the old judgment, okay? Old judgment means 2nd of May, right? 2, 3 months back. In this case, if somebody is not aware, I can just recap it. CIRP was initiated, Punjab National Bank initiated this CIRP in 2017, right? This is one of those 12 cases, right? BPSL was a prominent, okay, it's mentioned that it is. Plan submission and approval, COC approved the GSW plan with 97%, right? In 2018. So NCLT on in 2019, subject to some conditions, they approved it. NCLAT afterwards modified it a little bit, right? Now, please remember, this case is when we were at the very nascent stage of IBC. Many of our RP, we did not know what to do, whether timelines are, we were still learning. Courts were also learning, right, at that time. In this case, there was another, obviously, when such a big case, we will have PMLA and ED. PMLA attachment on 10th of October. ED provisionally attached the assets of PPSL under the PLP. What happened is, so obviously NCLT approved, NCLAT approved, and it went into implementation. So Supreme Court appeal, what it was, multiple appeals, including by Kalyani Transco. They are the OC, promoters, state authorities, everybody challenged this NCLAT order. And ultimately we reached to 2025. That is after 3 years. See, NCLAT modified it in 2020, correct? It's been almost 5 years. After 5 years, obviously it didn't reach, after 5 years, it reached in 4 years. But after 5 years, we got a decision that this is nothing doing. It was a wrong process. So process was upheld, then the outcome. So nobody, so here we were not talking about the spirit, we were talking about letter of the law. Fine. Strict timeline. It said section 12, SC held that the resolution plan was submitted. Now, okay, before I start with this, I'm sure all of you are aware that this has been stayed. Now, this order is no more valid on, so three-judge bench has stayed this order and now it is under consideration. And when we say vacated this order, it only means that the whatever this order was saying will not be implemented and we will hear it fresh. It doesn't mean that this goes away or they have approved everything. No, it only says that fine, this order seems not correct. We will be looking into it. Fine. Now the dates will be coming and we'll see how it unfolds. Uh, Till this was vacated uh, on 3rd of August, I think. Uh, Till then, this is how they were looking at. Now imagine if it was not overturned, then what the order is saying. We are only discussing that. SC held that the resolution plan was submitted well beyond the 330-day cap. 330 day we know. And this exclusion word is a very novice term, right? Nobody knows what does this mean. Nowhere in our code, I think we can find exclusion. It does talk about extension, but exclusion is something, under Rule 11 only. Here, as he said, 330 days is over. You're supposed to do mandatorily liquidation. This was not done. So Section 12 was not correct. Eligibility compliance, Section 29A, that 29 is ineligibility, right? Form H is the compliance certificate. Resolution professional failed to verify and certify GSW's eligibility. Now, GSW is a huge company, right? Somebody is offering 19,000 crores. They will have multitude of, you know, related parties and this and that. And please remember, this was right in the beginning. Huh? It's when the code was still taking shape. 6/6/2018 was when, we so many amendments were happening in that era. So here, RP did not, you know, fail to verify and certify their eligibility. Such procedural omissions vitiated the process despite no direct finding of illegibility. So it was not illegal. It was not illegal because of the, let's say, NCLT and NCLT both have approved. So how can you only blame RP, right? If they have approved, that means it's not illegal. But as per SC, even this was not taken care of. Okay, this goes off. Role of RP and COC. RP was always found, as is usual, right? RP was found remiss in discharge of duty by acting as a conduit rather than a fiduciary gatekeeper. The COC also failed to demand statutory accountability or enforce timeline. So I guess by now we all know that this was a pretty hard judgment, commenting on everyone, not only RP. RP gets commented on every order, but COC, NCLT, as well as NCLAT. Everybody was taken for a ride in this case. Issues analyzed, clean slate of commercial wisdom, as she said, that while commercial, wisdom deserves deference, legal compliance is non-derogable. So they said, fine. Supreme Court, as in Katina of judgments, have said commercial wisdom will not get into, but legal compliance is not commercial. That has to be done. Clean slate doctrine, which is 32A protection, right? It cannot shelter a plan that's fundamentally tainted. So if you read this order, it was a long order. Everywhere they found a fault in this. And why you're able to find a fault also? See, when there is a one mistake, two mistakes, right? So everything falls down, right? If something is delayed, what will happen? It will delay everything else, right? So if you are able to find fault in the first one itself, which was delayed, then obviously next one will also be delayed, isn't it? Interplay with PMLA, and PMLA, it was an amazing term which was used in this case, which was public law decisions. They said court clarified that PMLA attachments could not be overridden by NCLT, NCLAT, and these tribunals lack jurisdiction over the public law. Now, obviously, Supreme Court is saying this, and many of the NCLTs actually, if uh, they are not taking decisions, on PMLA matters anyways. They are all referring that you should approach the AA, Khan Market, Delhi, right? If you have any attachment, either approach the district court, the special courts we call, or you approach their AA and get relief from them. AA is not powered. That means our NCLT is not empowered, which to, most of the RPs will say that this is not a right stand, because then RP will, keep running from one post to other. Now this RP, if this happens, now what happens? If suppose this kind of thing happens, one RP can only do one CIRP at max, in my view. See, when there is a company which is, running, doing pretty well, the chairman has tens of people, right? They have directors, they have so many other people to rely on, full legal team, etc. When it's a CIRP, RP is actually running single-handedly. There are many times, and all the liabilities are obviously of RP. So if RP has to run to other courts also. Initial days, we were so happy that 238 is like, all encompassing. Our non-obstante takes care of everyone. In fact, all the ED matters, we were initially saying, boss, you have to stop it because now 238 is there. We are later law. We are working fine. But then when NCLTs and NCLATs also said that, we are not going to interfere in the ED matters, we'll see what will happen. Now RP will be now stuck on those matters also. And there the applications are 1,000 pages and all, right? So in one of my matter, one recent ED, we have filed appeal now because this judgment itself said it's a public law. So uh, till this order was there, we were fighting it at NCLT. The moment this order came, we now have approached ED with this assumption that after this order, NCLT will definitely not say anything. They will only say go to Falafala court, right? So as an RP, since all of you are RP here, my view, if you have any public law involved like ED, approach them as soon as possible, even though this order is set aside. Because this is a general perception where constitutional courts, they do not really give too much weightage to the tribunals. That is my personal view as an advocate. But they feel that constitutional courts hold much more power, much more, accountability, and tribunal should not interfere wherever the questions like public law is involved, right? And such thought or this thought process is evident in next cases also, which I'll be showing you. In high courts, high courts are saying something different, then Supreme Court overturns them. But my view, NCLT stick to whatever the it's related to the corporate. Anything else, do not assume you have to approach the respective courts. There will be a case of arbitration which is coming up. There also you will see how the high courts are taking decisions, not in favor of NCLTs and NCLATs, but in the constitutional side. So here the decision, I think you are aware that court quashed NCLT, NCLAT approval. Doctrine confirmation was legal and procedural integrity take precedent over deferred or lax implementation. Liquidation directions were given under 142. 142 is that Brahmastra. They order liquidation under 33. And why it made such a hue and cry? Because this was one of the case which got successfully implemented. Somebody invested 19,000 crores, and then they said after implementation, fine, there were flaws. They took extra time, they took extra years to implement. But then we should remember that we all have lived that Corona time, right? So everybody was shaken up. So if I mean that, that was the status. Status quo and review. We know that they have filed a review petition and now it is status. So this was our first case, which currently is in abeyance and it's vacated. Uh, any comment on this anyone has, or we can go to the next case? No? Okay. So since everybody is keeping quiet, I would like to ask a question to this August gathering. Anyone knows a reverse CIRP which is successful so far? It's been 8 years, 9 years, I think. Everybody's sleeping, huh?
Sir, Umang Real Tech.
Umang Real Tech. So can you elaborate little bit? किसी ने उमंग बोला, सर समझ नहीं आया कौन बोल रहा है, हु वाज दैट? इफ समबडी नो। ओके।
Sir, please go ahead. We will ask question later on.
अरे शशि सर, लेट मी ऑल्सो आस्क बिकॉज आई थॉट सब सो गए हैं लंच करके।
No,
सो
no, sir, we are hearing.
आई नो सीपी आज मिल जाएंगे सबको, जिसने फीस दी है, डोंट
We are
वरी अबाउट दैट।
patiently
सी
hearing you.
सी अदरवाइज इट्स अ वन वे ट्रैफिक। ये डेली आईसीआईसीआई ऑल्सो सेंड्स अस, आईसीआई ऑल्सो सेंड्स अस, live law also sends us these names. Unless you interact, I don't think it's going to get into the head ever. So okay, uh, enough said. This was a reverse CIRP, and this is first successful CIRP, reverse CIRP, which we are saying is implemented. In my opinion, not in my opinion, it's actually a fact. There is no concept of reverse CIRP so far, right? Our code doesn't talk anything about that. But this was an innovation of our NCLAT. Correct? Bhushan Saab had given this novice idea. Now, this is first case, Grand Realty Private Limited. I think it's a case in Ghaziabad. This was Satish Chandra Verma versus Grand Realty. Enclat is the forum in this case. 15th July. That means not even 1 month back, right? So this order has come where a reverse CIRP is settled. I mean, it is resolved through reverse CIRP. How? Section 7 admission was done in NCLT Delhi. Admission was done in 14 to 2023. Now see, within 2 years, within 2 years, it's successfully completed and implemented, which is a pretty good thing, right? CIRP was initiated against the Grand Realty Private Limited, CP number so and so. Obviously, when it was initiated, so many people will go challenge. Home buyers also went to challenge, and appellant also went to challenge. Appellant is the directors. Now, when they challenged, they said, only some OC is left, then why you want to put us through reverse, through this rigor? We will finish it. We will implement it. In this case, court monitored reverse CIRP, which is on 26/9/2023. During the appeal, Anklet allowed Pex Homes LLP to step in under a 2011 development agreement, proceeded with construction expressly to hand over possession to flat owners. Right? Here, Anklet permitted the developer to proceed with the construction so that possession of flats may be handed over. Now, being a RP of a real estate company, and I hope many of you must also be, that when a CIRP for real estate company starts, only sufferers are home buyers. Other people are there, obviously. Operation creditors never get anything. But I don't know, in a reverse, in a real estate CIRP, if the home buyers are even getting anything, they should be happy. No operational creditor, in my experience, gets anything out of it. Be it Aluwalia construction, you take any number. So OC, they are always on the suffering end. Even the FC, even though they are made to sit in the COC, most of them end up, other than possession. So only thing you can get out of in a real estate CIRP is possession. Money is not coming, for sure. If you can get money, if you can get possession, you should be more than happy. In fact, all the claims which are filed with RP, you know what happens, right? You admit them as claims, but actually it is for what? Actually, it's for possession, not for the amount. Amount you're admitting as a technicality, right? They are saying this is our claim, but we don't want the claim, we want the apartment. So here again, and CLAD said reverse CIRP is happening. Let the developer finish it. Developer completed the project. occupation certificate dated, so two occupation certificates were received. So, in Delhi, Gurgaon, Noida, we get tower-wise OCs, right? Operation. So phase-wise occupancy certificate is received. So here two OCs were received. Local commissioner was appointed. I think they don't trust RP. Yeah? So a local commissioner was appointed by Anklet, who verified the completion and recorded all the modalities. Supreme Court, what it was saying in the civil appeal number so and so, Supreme Court noted construction was complete and requested Anklet to conclude the appeal at the earliest, as delay was being attributed to RP. So everywhere problem is RP. Short court, SC requested the Anklet to ensure this it should be decided at the earliest. So what happened? Why it was not completed and why they were saying RP was not completing it? They were residual claims. Residual claims of only 4 home buyers and 1 income tax. So in this case, what happened? RP said that these 4 5 people are remaining. Please tell us what to do. And obviously, after Supreme Court's order, and glad they called everyone on 10th of July, which is last month. By hearing 4 home buyers, items stood resolved. Income tax said we have no objection as long as our claim is not extinguished. So they were happy to let it go. And these 4 people also they filed their affidavits and it was accepted. Now issues was whether Anklet can close an ongoing CIRP. You know what is who can actually close, right? Only NCLTs have the power to say that implementation is done properly or not, correct? Even liquidation, who can start liquidation? Only NCLT. NCLATs can state. Same like in Supreme Court, they started liquidation, but with their Brahmastra, right? 142. Otherwise, there is no process. Otherwise, you can't go to Supreme Court, say you start the liquidation. Here, only NCLATs can do it. Here, the issues were whether NCLAT can close an ongoing CIRP using an inherent power, which is when construction is complete, possession is handover, no stakeholder claim is remaining. Can we finish it? Obviously, NCLAT said yes, that is why this case is here. Where such closure requires a formal Section 12A application or can be withdrawn without insisting on 12A. So, after Byju's, right, the glass decision, uh, no one, no NCLT is even getting into this. They are saying file a proper 12A, then only it should be withdrawn. But what happens in this case? The reverse CIRP? Does 12A has any meaning? So obviously, once CRP starts, it can only be withdrawn through 12A. That's what our SC said. But in this case, does that have any meaning? Anklet said, no, it doesn't have much meaning. It said reverse CIRP validated and brought to a close. How? The bench recounted its so and so order initiating court monitored CIRP, or you can call it reverse CIRP, to deliver possession. They said there is nothing left, construction is complete, possession has been handed over, and no claimant also left. Now, when there is nothing left, why to get into that 12A thing? They said we are not, dishonoring Baiju's order, decision of Supreme Court, but here there is no such thing left. And that is the only reason we are allowing the reverse CIRP to get closed. And obviously, so far it has not been closed, not challenged. I mean, this in the same matter, they said, I mean, these were other matters like Sachin Malde, Hemant Naji Chadda, where NCLT said that uh, insisting on 12A when there is no creditor is waste of time and there is no necessity of any such thing. And that is why we are exercising our inherent power. Same like Gaurav Bhatia and Smriti Bhatia. It iterated that NCLAT can settle dispute between parties without insisting on 12A only when no other creditor claim remains post publication. In Baiju, there were a lot of other claims, right? OC were there, etc. So as an RP, please ensure if you are if you want to take away something from this, any one creditor left, it has to be then settled through 12-way process. If no creditor left, then obviously you can file under 11 and 60/5 and let them settle. They can, but otherwise it will not be able to. Right? Uh, Only income tax was there, which, where they gave their affidavit that as long as our claim is not settled, we don't mind it. Right? This was what is the name of the case? Satish Chandra Verma versus Grand Realty Private Limited. Okay. Any question in this, or I can move on to the next? No question? Total one way. Okay. Fine. This is our third case law of the day. Sincere Securities Private Limited versus Chandrakant Khepka and others. Again, this is an SC judgment. And when it's SC judgment, normally you know that they have already crossed NCLT, NCLAT, now coming up here, right? So somebody was so as an advocate, we say that we never lost it, right? Till we lose it in the Supreme Court review. So in this case, NCLT said one thing, Anklet said another thing, Supreme Court said yet another thing, right? So we will learn what happened in this case. Again, a very recent case. Facts of the case are Nandini Impacts borrowed 6 crore from A and B, 3 crores each, which mortgage part of the ground floor of one of the building, right? There's a building in Delhi. Now, title deeds were transferred on loan default through the CD, retained possession through leave and license. Now, it's an expensive office, right? It's an expensive office where rents were defaulted, right? This is fact of the case. Now, I'm sure all of you are aware, past rent is an operational credit, correct? But ongoing, so the person cannot ask you to vacate, the landlord, only when the current dues are paid. You cannot hold the current dues, right? And still uh, enjoy the property. So in this case, current dues were pretty heavy because it's a large commercial building. This place, COC and RP thought that it's a waste of money. They said we don't want to continue with the lease and license. Right? It's more like a onerous property, right? Onerous asset which we can let go in bankruptcy also, liquidation also, right? Can we do the same in CIRP? Any thoughts? Shashi ji or someone? No?
Sir, could you repeat the question, please, sir?
My question is, there is a real estate, let's say there is a CD. CD has its office, a flunky office, but now the CD is defaulting on the rent. Now CIRP starts. Now the landlord cannot take it back, correct? For the past dues. Current dues have to be paid regularly, correct? Now RP or COC thinks that we don't want to continue with this. We want to let it go. Can they let it go?
Sir, they can let it go, sir.
You were saying they can let it go. Okay.
Sir, if
And
in their wisdom, they believe that it is not worth paying the kind of lease rent which is payable,
Mhm.
Basically, this is a commercial decision which the COC is taking.
Then what happens to Section 14 moratorium, sir?
So, but this is not the property of the CD, na, sir. At the end of the day, you have taken this property on lease. And if you are not, if you believe it is not worth its while to pay the lease rent in the current scenario, then you might decide to hand over the property back. At the end of the day, this is not your property.
Correct, sir. So I guess most of us should be of this opinion, correct? As Rajanji, in my view, Rajanji has actually said what seems to be the only option. And any which ways, I believe that if they don't want to, let them stop paying rent. Landlord will automatically ask them to eject, isn't it?
Yes, sir.
So why do we get into the case where it reaches to Supreme Court and Supreme Court has to decide? So in this case, sir, what happened? UCO Bank, they were sole COC member. They initiated CIRP. This was admitted on in 2022. In April, I mean, within 6 months, COC ordered the RP to assess the viability of the property, observing that only 8-9 members were operating. Rental cost is so high. COC said this should be returned. Okay. Now, when they said it should be returned, you go to the NCLT, you say we are returning it and return it. NCLT issued an order directing the RP to return the possession. No problem. So NCLT approved it. Obviously, it was approved. Promoters were, furious. They said, how can you let it go? Our brand value, this and that, whatever story they must have given. They went in appeal. NCLT principal bench overturned this. They said Section 14(1)(d) of the IBC prohibits recovery of property during moratorium when occupied by the CD. Now, Rajanji, this is what I was asking. NCLT said no, and they actually overturned the decision. So that means what is the decision? It cannot be done, isn't it?
Yes, sir.
And it's not me as an advocate or you as an RP saying this. NCLT has affirmed. Now go little bit up and they said, no, you cannot do it. Now, what is final? We don't know, right? Now, final is coming now. It went to Supreme Court, obviously had to go. UCO and said, let's challenge it. Now, the question is, does Section 14(1)(d), which bars recovery of the property by an owner or lessor during moratorium, apply in cases where COC and RP, by mutual agreement and commercial wisdom, voluntarily decides to return the leased property? Here, there is no force. Moratorium is what? To save you, isn't it? What is the extent of judicial intervention permissible in COC approved decision? Right? Two issues were framed. Decision. Supreme Court said voluntary surrender versus coercive recovery. Supreme Court emphasized that Section 14(1)(d) is intended to prevent forced recovery. It does not bar the COC and RP from consensually surrendering property not required for CIRP. As you said, this was not the property any which ways. This will not become part of I am somewhere, anywhere, any which ways. Other than if it had a very, a rent of something which is minuscule and somebody will utilize it. Something like that, right? So voluntary surrender versus coercive recovery, they bifurcated these two. Primacy of CVOC commercial wisdom, so many cases, right? K. Shashidhar, most important one, affirms the COC's commercial decisions are paramount and non-justiciable, provided no voluntary statutory mandates, right? Rejection of obstruction by the suspended director had went there, right? Objections raised by director so and so were dismissed as unreasonable delay techniques in either paid rent areas nor offered just grant for rejection. But imagine principal bench had overturned it. They read 14.1 as no, it cannot be done. So as an RP, my humble opinion on maybe suggestion, nothing is final. Think what is happening. Write everything in the minutes or why you are taking a decision, and then go for it. So please remember this case if you want to.
May I
Since
come?
yes, yes, please.
Okay. So, sir, like now, Honorable NCLAT decided in this matter that Section 14(1)D is applicable and you cannot go against it, cannot violate it. Now, what follows from this? What follows from this? That means the CD has to retain the property. Now, two things will come out, sir. One, either the CD will be in a position to pay the rent, or
Correct.
CD will not be in a position to pay the rent. What further follows is that, assuming that the CD is in a position to pay the rent, assuming the COC is funding the CIRP, right? Still, should it be forced to pay the rent which it does not want to pay such kind of rent? Means at the end of the day, this expense is an you can say it is only increasing the cost of the CIRP, sir. It is not helping anyone.
Absolutely.
So,
Absolutely,
sir, I was handling one CIRP, my first CIRP, which was I was handling. So the company had it plant somewhere in Maharashtra, nearby 100 kilometers from here, and they had an office here in Mumbai. So COVID had come, and it was not possible to use that office.
Use it.
And we decided that let us run the CD from my office wherever required. Means I could, whatever basic action could be taken from my office, and all documents, papers could be moved to the factory office, right? So we changed the registered office of the company to the factory address, and we vacated the office and we handed over the property to the landlord. But and in this particular case, our case, there was no litigation from the suspended directors. So there was no litigation, but at the end of the day, the COC in its wisdom said that, and even I concurred that it is not advisable to pay this kind of money when it is of not any use to us. So,
Absolutely.
So that
Sir,
is
when Rajanji, as you rightly said, till there is no objection, there is no problem. Correct. Problem comes when somebody objects. And when somebody objects, your own tribunals, they take different opinions, they view. I mean, see, when we read it like this, voluntary surrender versus coercive recovery, obviously we'll say, it's pretty easy to decipher, right? Coercive recovery, section 14, boss, you cannot do it.
prohibited.
I don't want to vacate, I don't want to vacate. Simple. You cannot do it. But voluntary surrender, how can somebody says, no, you have to continue with it? But it does happen in our, uh, you know, the domain we are working in. So that is why I'm saying at times orders are not really correct also. So as an RP, don't worry if there is some adverse remark here and there. These can be taken care of in the appeals. So this is a pretty good example of Sincere Securities Private Limited. I don't think any of the RP will object that this is a wrong decision of Supreme Court. This is a very good decision. If I don't want to do it, I don't want to do it. What's wrong in that?
Circulated करनी
Okay. So final order, they have set aside the NCLAT remand. Amit ji mute कर लीजिए and restored NCLT's direction for the RP to deliver possession of the appellant without delay. Correct? So name of the case was Sincere Securities Private Limited, just in case somebody wants to. Another case, this is an interesting case if you are not aware, and it's little bit out of IBC. Little bit out of IBC means not NCLT, NCLATs are not in disagreement here. Here somebody else is in disagreement. And this has recently been decided in 21st April. Uh, ESL, which is Electro Steel Limited versus Ispat Carrier. In this case, what happened is MSME arbitration was going on. Most of these companies, obviously IBC starts much later, right? Before that, we have so many forums. We have MSME conciliation. MSME can either direct it for their own arbitration or they can give it to the High Court arbitration, etc. Right? All that also happens. Now, in this case, what happened is this is I think again a Calcutta bench. So in this case, Ispat Carrier and MSME filed claim under MSME Act for 1.59 crore. Not in IBC, in MSME Council, before the West Bengal MSME Facilitation Council. Arbitration followed because conciliation had failed, and arbitration within the MSME facilitation. IBC was initiated and plan was approved simultaneously somewhere, right? A CIRP was initiated against Electrosteel, and again it was right in the beginning, 2017, leading to a moratorium. Ispat Carrier, they said, fine, moratorium is there, we cannot continue this arbitration. They filed their claim. Now, in 2018, Vedanta's resolution plan was approved. Plan deliberately settled all operational creditors as nil. Nothing. कोई पैसा नहीं. Since liquidation value is zero, you have an option to clear. NCLT approved that plan. Fine. Now what happens? Now, obviously, the moment plan is approved, what happens? 14 goes off, moratorium is removed. When moratorium was removed, they again started arbitration award and execution. Facilitation Council proceeded with and passed the arbitration award. Fine. As soon as, if you see, April 2018, they passed this NCLT, and within 2 months, this was passed. Arbitration award was passed. Now, what happens in arbitration award? Either you accept it or you challenge it. Correct? You challenge it under Section 34 of Arbitration Act. Now, what happens is, it was right in the beginning. We all were very happy, boss. Clean slate principle, 32A is there, nothing doing. All the past liabilities are wiped off. Electrosteel did not challenge the award. See, in resolution plan, their award was zero, right? Nil. It's not that उन्होंने 10 रुपए दिए, 100 rupees, nothing. It was nil. But it was considered. Electrosteel did not challenge the award under Section 34. Not challenge means you are accepting it in a way, right? If you look at the Arbitration Act, it says if you're not challenging it within, I think there also it's 90 days. If you're not challenging it, you are accepting it. Ispat Carrier sought enforcement. They said, so we have a decree, now we will execute it. Electrosteel, now at this stage, when they went to enforcement of the decree, they countered by arguing that the award was a nullity because the claim has been extinguished as per the approved resolution plan. हुआ क्या? Both the executing court and the high court, they rejected this. They said objection should have been taken under Section 34. At that time, why you did not tell us? Now at that stage of execution, you are coming and telling, whatever we are doing is crap. We cannot do it. This will not be done. Imagine the situation now. Your plan is approved. One code, a thick code says all past liabilities, don't worry. Only the minimum liquidation value should be paid. High courts are saying, no, you should have done what? You should have challenged it under 34. Why you did not? Since you did not challenge, it's not nullity, it is finality. We might go ahead. This is the fact, right? Now, issues, obviously, Supreme, it is coming to Supreme Court. I'm telling you, Supreme Court decision, right? So obviously somebody has challenged it. Now, whether claims not included in the approved resolution plans are extinguished, making any subsequent arbitration award void and non-executable. This is the issue. Whether an arbitral award not contested can be resisted at the execution stage. And section 47 CPC is, where you decide who is the, suppose the award is against you, then your legal heirs or your representatives, etc., there. So they say whether it's a nullity, because now it is not a new person has come. Whether that new person can be considered your representative or legal heir or something like that. So they had to decide on these two issues. They said, okay, we'll decide on these. Now, decision was clean slate doctrine, right? 32A, the section now we have. Resolution plan finality. Court affirmed that a resolution plan approved under 31 of the IBC is binding on all stakeholders, including operational creditor and statutory authorities. All claims not provided for in the approved plans are extinguished. Court cited landmark judgment, obviously Ghanshyam Mishra. Ghanshyam Mishra, now even Supreme Court in all the matters, wherever people are saying they are not coming, this order plus 32A is used that no, it has attained finality. This is the decision. And jurisdiction of that 34, that why it was not initiated, 47, what will happen, all that was set aside. They said no. Conclusively, they said they quashed the execution proceedings and set aside both the executing orders, executing court's order and High Court's order. Now, this judgment reinforced that lifting of the moratorium does not revive extinguished claim and execution must yield to clean slate. Now, why I'm bringing this decision here? Okay, now all of you must have said that 32A is so clear, Ghanshyam Mishra is so clear. Why are we even discussing it? We are discussing it because, see, executing courts, I mean, we can still understand, right? Maybe they are lower courts, right? Even high courts are taking a decision that no, 34, 30, 47 stays and we will be executing. Clean slate is not given. So when we say the law is so clear, law is so black and white, I am again trying to portray here is nothing is so black and white. You will end up defending it. Imagine if these people, if suppose, see, you are not only RPs, right, or IRPs, you're also consultant when you're making repayment plans, resolution plans, right? So at that time, please advise your clients, do not leave any proceedings. In my view, if they had challenged it under 34, it would have been much easier for them than fighting it in Supreme Court and coming under this clean slate principle. Or at least inform them that no, this cannot be proceeded. So that was the only reason of bringing it here. It was Electro Steel Limited versus Ispat Career Private Limited, where Supreme Court overturned High Court's decision saying no, 32A prevails, Ghanshyam Mishra prevails, past liabilities cannot come here. And in my view, this could have been done only this was possible only because the claim was considered. In case the claim were not considered, even this would have, don't know which side it would have got. But since their claim was properly considered and then made nil, commercial wisdom was upheld.
Sir, may I come in?
Yes, please,
With your
Rajan.
kind permission.
Thank you, sir. You please keep coming. I get tired at times. Yes, Rajan. Please.
So 2 points which I want, sir, you to consider
Sir.
is that alternatively, had the SRA, right, gone approached NCLT, right?
Correct.
Once the order was passed by the MSME tribunal, arbitral tribunal, right? At
Correct.
that point of time, one option could have been that they could have approached the NCLT stating that this matter pertains to IBC. IBC, we have got an approved resolution plan, and now these people are approaching alternate authorities, forum shopping, and trying to revive claims which pertain to period prior to insolvency commencement date, right? So this option could have been taken by them. One, two, and sought an order stating from NCLT stating that these proceedings cannot lie. One, two, sir, had this operational creditor not filed a claim, and even if the claim was not considered, right? Once the resolution plan is approved, all claims prior to ICD, they are basically extinguished. So if that is the case, then even in a situation where the OC had not filed the claim, then also probably the same result would come, stating that clean slate principle, and therefore whether you filed claim or you did not file claim, at this juncture, you are not going to get any relief.
Sir, when this 32A was uh, enforced, which date? No,
Sorry,
it
sir.
was, when 32A came into our code.
Basically, because of those criminal actions which were
No.
coming up.
When, sir, when? I'm saying
Uh-huh.
when. It was in 28th December 2019. So after 3 years, right? 32A came into picture. It was inserted, that amendments, etc. See, whenever there is A, it is amendment, right? So not in the initial ones. This was lit. So these, see, high courts, they take sweet times, right? Execution courts, etc., etc. And obviously, it's coming now. If you see, when is the date? I think it's 21st April 2025. The plan was approved in 2018,
Okay.
right? After 18, the execution order was passed. 6 July 2018. Till this time, we did not have any 32A, correct?
Okay.
We did not have. When we did not have, then obviously they will read into it. Now, when they start reading into it, I've already told you, sir, nobody likes tribunal Raj, right? हमने वैसे ही उनका ओएल का काम छीन लिया उनसे हाई कोर्ट से तो they are against us. So whenever they get a chance to whip you, they try. Hey, that's my because it's a learning setting. I can comment such things. Normally, I will not do it in my code, but I mean, what you are saying is also right, sir. After 32A, obviously it's so clear. After Gancham Mishra,
No,
it
but
is
sir,
so clear.
why 32A should come into picture here? Sir, 32A gives you protection from prosecution in criminal cases,
Okay,
right?
32A, we call it clean slate, right? That, okay, whatever has happened in the past has happened. Any claim, it should be wiped off.
Okay.
Any claimed is wiped off. Any prosecution also wiped off. Wiped off for the CD. Obviously, the other things they continue. For CD, there is no prosecution. This is about claim. Why? And what you rightly is saying, even if 32A is not there, even if I am agreeing with you, sir, that even if it is not there, when the law is so clear, which is a very recent law, any claim not included in the repayment resolution plan should be wiped off. But it was not done. I'm only showing you, even High Court rejected and they said no, objection should have been taken under 34. So either the lawyers were not efficient enough in this case at High Court, who could not, put it, but then they succeeded at Supreme Court. So I mean, see, we are not commenting on right and wrong. We are only trying to learn that even such situations happen. When some court will say, no, you could not do it. as RP, I think just remember few things. Kancham Mishra, boss, we will be doing it. Even if, let's say you say, okay, Kancham Mishra was NCLT, NCLAT, even High Court's orders have been upturned. I there might be some people who will say, oh, if we go through constitutional courts, then what will happen? Even then, Supreme Court is reversing. They are saying no. IBC prevails, Ghanshyam Mishra prevails, 32A prevails, resolution plan, commercial wisdom prevails. Okay. So, clean slate doctrine, I think we have done this, right? Okay. So, this is our fifth case. After this, we'll have a small break and then we'll have a few more cases. Today, nobody, I mean, other than Rajanji, I think nobody is discussing. So we are going pretty fast. Otherwise, there are times when I end up only finishing 4 or 5 cases because there is a lot of questions, lot of discussions. Uh, Today, luckily, we are running fast. Okay, so this is the fifth case law which we will study today. Not very recent, around 8 months back, 29th of January. This was in Independent Sugar Corporation versus Girish Sriram. If anybody is associated with any of these cases, then please tell us because it will be better to hear from that person itself, if we are aware of that particular case. I'm not personally involved in any of these matter as a lawyer. I am only giving you my interpretations. Okay. So Independent Sugar Corporation versus Girish Sriram. This is the that Competition Commission of India thing comes into picture. So wherever uh, 31 subsection 4, right, we have to take care of that. This is what we are going to discuss in this case. So Independent Sugar Corporation Limited versus Girish Sriram Juneja, etc., etc. CIRP of HN, these are the facts of the case. CIRP of HNGIL, competing resolution. So obviously, I'm not starting where it started, etc., etc. We'll straight away come to competing resolution plans by AGI Greenpack and INSCO. INSCO is a independent sugar provider. AGI Greenpack is a big company, right? AGI plan involved a competition act. So competition combination requires CCI review that, whenever somebody is becoming extra large or huge, then somebody has to oversee it. And when you say oversee it, that means you need an approval from that, saying that fine, you can take it over, you can merge it, etc. That those requirements. Those were challenges. Now, before COC vote, that is 28th October, AGI, this is which is the SRA, right? Their Form 1 had been rejected. Obviously, a fresh form was filed. Now, CCI approval was not in hand. They had filed it, but they did not have it. Approval was not there. Now, fine, approval is not there. What happens? COC approved their plan. Approved with 98% majority, right? Overwhelming majority. Not 66, 98. NCLT and NCLAT, what they did? They upheld the process. They said, no, it's fine, no problem. They said CCI node is mandatory. Yes, we agree. But timing is directory. Now, as RP, who are not advocates majorly, this word is pretty interesting. Mandatory, directory. Some things are held mandatory, some things are held directory. At times they are mandatory for X person and directory for Y person. So 48 hours circulation of minutes is mandatory, but 7 days admission is directory. So many things are directory, many things are mandatory. Here also what happened is NCLT, NCLAT, they said that fine, 31.4. Uh, have you heard of 31.4 or should I read it once? I'll read it once, I think, if it is not already there. Oh, yes, there is. So I don't have to read it right now. I'll read it. Now they said, no, fine, it is okay. We are passing it. They cleared it. Fine. Obviously, they cleared it. Resolution plan is now implemented, is being implemented. What happens is in scope, which is the unsuccessful RA. Now, tell me, uh, since all of you are also senior here, unsuccessful RAs, do they have any locus against the plan?
You mentioned that their locus was accepted. When I read that sentence, I was, trying to work on that only, sir. Basically, ideally, they don't have a locus. So, an unsuccessful resolution applicant is not allowed to, you cannot challenge arrange the resolution plan which is approved. So, I was just wondering how locus could have been accepted here, sir.
So that is why I'm getting these cases, right? Hopefully for some learning. So normally in most of the cases, if you go to NCLT, NCLAT, they will not take it. Correct? They will say, no, there is no locus of unsuccessful RA. Because if you start accepting their locus, then it will be a never-ending process. Somebody will keep coming, new people will keep coming. So that is why we don't accept their locus in most of the CIRPs. In this case, unsuccessful RA challenge COC approval for want of prior CCI clearance and other process lapses. This locus was accepted at Supreme Court level. We'll see what are the issues. Okay, we'll discuss this, sir. Rajanji will come back to this locus thing.
Okay.
But right now so locus is one thing which at times I don't agree, and as you also don't want to agree. But we will see the entire case. Then you tell me whether it's a good decision or not. So proviso to section 31(4), IBC makes CCI approval mandatory before COC approval. Consequence for a COC approved plan without prior COC approval, what will be the consequences? So these were the issues. Now, what does our 31(4) says? It says, I think it's not there. Let me read it for you, okay, from the book. It says COC 31(4). It says COC may approve a resolution plan by a vote of not less than 66%, as the case may be provided. Proviso is provided that the COC shall not approve a resolution plan submitted before the commencement of the IBBI Amendment Act so and so, where the applicant is ineligible under 29A and may require the resolution professional. Correct. Sorry. What am I doing? What is this here? Sorry. I was reading 34. Sorry. It's 31(4). A resolution applicant shall, pursuant to the resolution plan, blah, 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 within a period of 1 year should obtain all other approvals, etc., etc., right? All the approvals after the resolution plan is allowed for other approvals, right? You need a DTCP approval, any other approval, provided where the resolution plan contains a provision for combination, as referred to in section 5, right? This CCI thing. The resolution applicant shall obtain the approval of the CCI under this act prior to the approval of such resolution plan by the COC. So this provision is pretty decently clear. They said shall is mentioned and it's mentioned as a proviso. So that means it's pretty clearly mentioned in a, it's not like, those small letters. It's properly drafted proviso. And it clearly says shall. If competition is involved, CCI thing, it has to be obtained. And prior to the approval of COC. Now, what happens in this case, what our Supreme Court said. So please remember, NCLT had approved it. NCLAT also approved it. Now it came to Supreme Court. Supreme Court accepted their, contention of the failed RA, and they said they framed the principal issue whether the approval of a proposed combination must mandatorily precedes the approval, right? Plain meaning rule क्या होता है? It says it must be presumed that the legislature inserted every word in a provision for a purpose. When there is no ambiguity, court is duty bound to proceed on the footing that the legislature intended what is written. So no need to read into everything. Our plain meaning rule says that, right? In jurisprudence, if you have learned, jurisprudence says plain meaning rule means जो पहला meaning है वो. Don't read too much into it. The court is duty bound to proceed on the footing that the legislature intended what is expected. Court's exercise cannot be stretched to involve rewriting, recasting, or reframing of the legislation. Correct? See, only Supreme Court can do all that, right? NCLT, NCLAT is no. Notes on clause or moratorium traced both expressly states CCI approval for combinations must be obtained prior to the approval of COC. Correct? Now, this is what the Supreme Court is saying. Again, in Supreme Court, see, the decision is by 2-1. So, 3 people, 2 are saying something and 1 is still saying something else. So, whenever you are hiring lawyers, just on the sideways, I'm saying, it's not that what this person is saying is wrong. He may not be agreeing with you, right? So, whoever agrees as an RP with you, you should take it up. But it doesn't mean that a particular person is wrong most of the time. It's their view. Here also, it is a majority decision of 2:1. Justice Bhatti had a different opinion in this. So, what opinion was there, that I will come later. But decision was a resolution plan lacking prior approval wherever combination is involved does not pass the muster and contravenes, this law of 31(4)(1)(2)(3). COC approval has no legal meaning. They are saying this is not commercial wisdom. Legislature is pretty clear. CCI approval लगेगा तो लगेगा. No questions asked. Should not be. They are saying don't read into it too much. Outcome, what was the result? If this decision comes, it says AGI Green Packs plan set aside for want of CCI note. And status quo ante. Status quo ante means at that time, whatever was the status quo, COC to reconsider the appellant plan, any other plan. So if it is appellant's plans or any other plan, which has CCI approval as on 28/10/2022. If it is not there, do not consider it. Imagine the plan passed by 98% of COC, and obviously, when CCI is involved, it's a large case, right? It can't be a
Small case.
small case. So it's a big case overturned by 2-1 majority. What the one person is saying? Okay, so locus is this one, sir. Before that, we'll see the locus. Court affirms locus of an unsuccessful RA as an aggrieved person under section 62 of IBC or 53T of Competition Act, where its plan could otherwise would have been approved. Right? So it's not that they are saying that no, every successful RA has a right or locus. नहीं तो everybody will go to NCLT tomorrow and stand there. They'll say Supreme Court has said you have to accept. Here they were pretty clear. They said only under Section 62 or Section 53 of Competition Act, since their plan could have been approved, they are as good as a successful RA, not a unsuccessful RA. They have a pretty decent chance. Because obviously, when the top guy goes out, what will happen? You will get into picture. You know what is Section 62?
Appeal to Supreme Court, sir.
Correct, sir. So whenever it's Supreme Court, Section 142, Section 142 of Constitution, right? Article 142 or 62. These things really don't matter, sir. They are saying they do have locus. Luckily, they said under 62 only, not under NCL,
So what about the locus at NCLT, sir? It has to first start with locus at NCLT. You cannot go to Supreme Court directly. You have to travel the whole process. So if NCLT says you do not have any locus, but basically, so either you have locus or you don't have locus. Now, basically what I would say is that, sir, all unsuccessful resolution applicants, they had a good
Yes.
chance of their plan getting approved. For XYZ reason, the COC has not chosen their plan, but they have chosen some other plan, right? So for whatever reason, if you are an unsuccessful resolution applicant, how in particular cases some unsuccessful resolution applicants will not have the locus, and in some cases some unsuccessful SRAs will have locus. Sir, this is I say, sir, this is very, 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 very subjective in the sense that and as I said, sir, what about the locus at NCLT? What about the locus at NCLAT, sir? How can you say, is it sufficient only to say that you have locus under Section 62 of IBC? That is what I come to. And sir,
Any other viewpoint on this, as Rajanji is saying? कोई है और राजन जी आज आप ही के पैसे वसूल होने और किसी के नहीं होते।
सर एक मैं और ये कहना चाहता हूँ सर, right
जी
now I want this gathering to take this very seriously, please. So
Okay.
I am leading you somewhere, sir. Can it be said that the resolution plan, which was vetted by the resolution professional, and since the CCI Competition Commission permission was not available prior to approval of the resolution plan, so this plan was not compliant as per the provisions of the code, and therefore the resolution professional has erred in presenting this plan before the COC, and therefore disciplinary action should be taken against the resolution professional.
What do you want the gathering to do, sir?
I consider this. What I am saying.
Consider this. Okay.
Whether what I am saying is it makes sense or is it means.
Sir, you have the answer here. I'll tell you why you already have the answer. See, if you look here, who approved it? COC approved it.
Yes, sir.
NCLT approved it? Yes.
Yes, sir.
NCLAT upheld. No problem.
Yes,
Right? Everybody is approving.
yes, sir.
Now, when you go to Supreme Court, even in Supreme Court, one person is not saying no. It is correct. You know what that other person is saying? Is saying this. Yes, this is the dissent. Justice Bhatti. Dissent treats the proviso as directory, stressing IBC timelines and administrate. And anyone who has ever dealt with CCI, proper sarkari log hain bhai wo. Administrative realities at CCIs, anybody has considered? No. So the dissent said, It stressed on IBC timelines and administrative realities at CCI. It reasons that compliance can be assured by the time AA considers the plan, not necessarily at the COC stage. So he said that fine, if they do not get CCI approval till the plan is considered, you file a resolution plan today and it takes 2 years and 3 years at times to get passed. I'm sure all RPs must have experienced that. It's very rare, unless it's a crore, 2 crore, 10, 5 crore company, it's separate. But any large corporate, you have 20s and 50s of IAs challenging that. Until all the IAs, other than Buffet, are cleared, resolution plan can't be passed. So they are saying, so Justice Bhatti said that fine, we'll consider it. It's not that we are not saying that it should not be done. Only thing is whether it should be done at this stage itself or can be done later. That is the only thing he said.
Sir, I have a point of view here, sir. Kindly, if you permit, sir.
Yes, please. Sir.
So, sir, see, section 34, right, sir? Now, section 31, subsection 4, right? Right? Now, it says that approvals can be taken in 1 year from the approval of the resolution plan. The
Correct.
proviso singles out only the
CCI.
CCI. So,
Correct.
if the proviso singles out only CCI, then in that case, basically the intention of the legislature is very clear and absolutely unambiguous, and therefore the letter and spirit of the law has to be followed. So I am of the opinion, sir, personally, that because it is very clearly mentioned that the SRA has to take prior approval of such resolution plan before the committee of creditors consider this plan, the CCI approval should be in place. This is the proviso. So if a proviso is very clear and singling out CCI, then in that case, the intention of the legislature is very clear. And therefore, for this proviso to say that it is discretionary, with all due respect, I believe, sir, it cannot be taken that way. That is my humble opinion. And apart from
no, sir. Perfect. Okay.
And apart from that, where I come from, sir, I'll tell you, sir, where I come from, sir.
Yeah.
So can I very relevant to what you are saying, sir. You mentioned that the plan was approved by COC. You mentioned that it was approved by NCLT. You mentioned that even the challenge survived at the level of NCLAT, right? Now, correct. Even of all these things are there, the fact of the matter remains that the position of law was that CCI approval was required, and if CCI approval was not taken, then in that case, the RP has erred in presenting this resolution. He should have rejected this resolution plan. He has erred in presenting this resolution plan before the COC for consideration. Now, I'll give you one example, sir, which I personally faced, sir. It would be interesting for all to know. Please. May I please, sir?
Yes, sir. More than welcome.
So
please.
I was the RP in one CIRP, wherein the SRA had put a clause in the resolution plan stating that we will honor the plan, say on the 46th day, all implementation will take place, but it will be subject to any litigation pending in the matter. So if any litigation is pending in the matter, we will honor the plan only after all litigation has ended, and on the 7th day from the end of litigation, we will ensure that the plan is implemented. There was a challenge to the plan. So the SRA said we have already put in a clause that subject to litigation, so we will have to wait till the outcome of the litigation, right? Sir, in the meantime, the RP, after the plan has been approved by the
you were the RP, you said in that case.
I am the RP, right? So
okay.
the resolution plan was approved, sir, right? This resolution plan with this clause was approved by COC, approved by the adjudicating authority. Right now, the resolution approval of resolution plan order said that RP to bring on record status of implementation, preferably at the end of every quarter. So I being
Correct.
part of the monitoring committee, chairman of the monitoring committee, I was filing the status of
Correct.
implementation. So my first status of report was accepted by the adjudicating authority. In the meantime, the bench changed. I filed the second status report. Second status report, the bench came heavily on me.
Yes, yes.
I was personally arguing in the matter. So bench
Okay.
says, how could have you
Present this,
present this plan to the COC, because this
which
plan,
is non-compliant. It's conditional,
so they did not use the word conditional. They are saying that this plan is contingent on
contingent.
on
Correct.
on
On an
litigation.
uncertain event in future, right?
So
And
how
what stops them from creating a litigation?
whom, sir?
Sir, SRA,
No,
they
SRA is
themselves
not
can
creating
create
litigation.
litigation. No,
SRA is saying we are here to honor the plan. We are not
no,
back.
no, 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 no. I'm saying something else, sir.
Hmm.
Sir, we live in India, right?
Hmm.
If this kind of plan is presented and COC is approving, see, I don't know the name of the case. I don't know anything, right? No background.
Hmm.
I'm only saying what stops them from getting one person from somewhere and creating a litigation. Litigation you can create anywhere, isn't it?
Hmm.
So suppose they don't want to pay for next 6 months, they will file an appeal and 6 महीने तो नोटिस में ही निकल जाना है सर.
So, sir, I want to say this, that see, the
Yeah.
SRA has not filed any appeal. The SRA says we are just for this plan. We want to implement it. They are stating time and again, they are stating we want to implement, but subject to this clause, right? So, subject to this clause. Now, coming back to the adjudicating authority says that this plan is a contingent plan, right? So I even mentioned to the bench very clearly that this was the commercial wisdom of the COC, and they have actually cleared this plan with 100%. So if that is the case, the bench says nothing doing. We will come after you as the RP and as
Yes.
the chairman of the monitoring committee. So I have been asked to file an affidavit why I allowed this plan to be presented before the COCs.
I know, sir. And I don't know if you have already got the show cause notice or not, but you know what is going to follow.
No, sir, I'll tell you, sir. So what has happened is, sir, see, in this particular case, the suspended director, see what is happening, sir. Suspended director, basically absolute non-cooperation from his side. Nothing means he has given nothing. Nothing means nothing, sir. He has only created problems. Let it be. That
Correct.
जो वो उसका jurisdiction है, वो उसकी फितरत है. I grant him that, and
रहेगी,
I
correct.
have to pass through everything. So
Absolutely.
I don't have any complaints against the suspended director. So the appeal at NCLAT based on frivolous grounds are already filed by the suspended director. Now,
Correct.
suspended director belatedly, sir, very belatedly, after 1 year, they filed complaint with IBBI against me, and they mentioned everything under the sun. Whatever I did in that
Correct.
therapy, they questioned that. So
Correct.
I basically engaged with IBBI. I said the form which they have, which you have sent to me, they have not signed the verification part. This complaint they have filed after 1 year. Now um, the relevant regulations say that it has to be filed in 45 days. And in similar grievances pending appeal before NCLAT, would you still want to the RP to reply to whatever he has mentioned in the complaint? So I got a very single line response from IBBI. Why don't you file your response? So I filed my response, and
You will have to file, sir. Yes.
I filed.
Mm.
So I filed, and I'm very thankful to IBBI that at least they took decision in 1 month. In 1 month, they took decision and they absolved me of all the charges, whatever there against me.
Yes.
So
Yes.
what I am trying to say is that, sir, at the end of the day, आप आरपी को सर कितना सर आप आरपी के पीछे जाओगे सर. मुझे एक कार लास्ट सर ये चीज पे मेरा एक आईपी है. आईपी रजिस्ट्रेशन मुझे मिलना चाहिए. आई से एट ऑल forums that see this edifice of IBC rests on 4 pillars. One is the RP, one is the adjudicating authority, one is the IBBI, and one is the COC. Sir, बाकी तीन pillar जो है, they are not answerable to anybody, and anybody and everybody means the RP is answerable to them, and anybody and everybody. So any person has a locus against the RP, you can file complaint, you can approach IBBI with the smallest reason, and the IBBI wants to go through the whole process of complaint mechanism. सो ये सिस्टम में सर ये नॉर्मली है सर, ये आरपी और आरपी को आप देते क्या हो सर एट द एंड ऑफ, इट्स नॉट अबाउट मनी एक्चुअली, मींस वो आप मेरे को 10 लाख दोगे भी तो भी व्हाई शुड आई गो थ्रू सर। ये सीआईआरपी में सर सस्पेंडेड डायरेक्टर इवन filed a police complaint against me stating that I stole jewelry worth 20 lakhs of rupees from.
Sir, I have one more case which is coming, after this, and you will be surprised to know the decision in that.
Okay,
I
sir.
hope that doesn't happen. Sir, you are touching a very, very sensitive topic. I guess today if we touch that, all RPs will cry right here. Okay, so I'm handling a real estate CIRP. Now, in real estate CRP, we say if you don't get complaint at IBBI, then you're not working. Because as RP, you cannot, help everyone. Somebody will definitely be aggrieved. IBBI, see, if they're asking you, you don't have a locus to say that, oh, this is already sub judice, why should I tell you? Now, that is a wrong thing. That I think you should tell them. Whatever you tell them these people also. What stops, there is nothing you're hiding. At times, I believe even IBPI gets little too far. Even if somebody has not filed it, sir, they are actually reading the NCLT and NCLAT orders. And if they find a single adverse comment, at times they'll ask and question you, which sometimes I say it's fine. I won't be able to say no to it. I think RP is too much regulated, sir. Is regulated from every side. COC you can't do anything. NCLT you can't do anything. I don't know what NESL is doing. NESL is even stopped, publishing the auctions these days. I don't know what they are doing. So till 3-4 months back they were doing it. So all these other pillars cannot be done anything. Only pillar who can be touched upon is RP. And that is why as RP, please stick to letter of the law. I always say in all my training programs, I said, please don't be Rambo. Don't try to, take a gun and shoot everyone else. Just realize your limitations. Maybe you are a lucky guy that you got fees also. There are so many times when RP doesn't even get the fees and still has to answer all these things. Uh, these are, sir, part and parcel. We have become RP. That is our choice. Nobody forced us to become RP. You can, and that's a fair argument also at times. They are saying, are we calling you to become an RP? Don't become an RP. There are thousands of people. There are you know how many RPs are there, right? 4,500. Out of them, only 50% have AFA. Why? Half of them have left, which is okay. It's their choice. They have left, no problem. So whoever is left, they want to do it. And in my view, sir, we don't. I don't think it's a profession. End of the day, it has become like a business. You end up putting from your money. You'd never get monthly. If you are getting monthly fees, you are a really lucky person. Uh, it has become a business. You continue paying your team, you continue paying others for 6, 7, 8, 9 months, and then you end up somewhere. If liquidation happens, liquidator will fight with you and don't know whether your fees will come. So these
Sir, I'm
issues are
Devang
there, sir.
Sampat speaking.
Devangji.
Sir, I'm IP Devang Sampat speaking.
Yes,
Rajan
Devang
Bhai
sir.
knows me very well and some other participants also. Sir, I would
Okay,
like
sir.
to add certain points
Please.
on the issues of CIRP. Now, when we speak of commercial wisdom, it's unique in Indian insolvency law, which is nowhere in the world, where only
Yes.
financial creditors decide on the fate of everyone. Actually, it is a legal fraud. I'm using very powerful words. in my humble understanding, it's a legal fraud on the people, on the creditors, where the rights of creditors are taken away without allowing them to vote. Everywhere in the world, it's all creditors who vote. Here, financial creditors vote on the rights of other creditors who don't have say on anything. Second thing is commercial wisdom in Unicitral or any other part of the world involves only basically the decision on plan and the at the most decision on interim finance. Here, Section 28 was there, but now even running of the operations goes to COC and stakeholders. Now, there was no stakeholders initially in insolvency. In fact,
Correct.
there is IBBL document itself which says that what are the rights of COC and what are the rights. In fact, some of the IPs had made it and then given it to IBBA, which IBBA published, which is, I forget the name of the exact document, but it says what is the domain of IP and what is the domain of COC, in which running of the operations and administration was clearly the right of insolvency professional. But all that rights have been taken away by COC and they are having all authority and no responsibility. And maybe the fees, etc., all these issues. I don't know what was the compulsion. Maybe some great experts say that the compulsion was that there is delay in implementation in other laws. That is why IBC was brought in to help the bankers. But in this way, it's old wine coming in new bottles and new laws, and the system is never improving. So possibly we are just a part of the system which we did not realize, and maybe the system is not changing, and we are being caught in the system. What needs to be done is increasing the number of judiciary. I'm not talking only talking of honorable NCLT, but the entire judiciary, where the disposal case of average Indian is over 300 years, and it has to be reduced to over 1 year. So the infrastructure of judiciary has to be increased in a quantum way by 50 to 100 times. We need to genuinely increase the ease of doing business, bureaucracy, etc. In this way, we are just maybe finding a scapegoat in IP to allow the system to work in the way it is going. We were just a part of the cog which we did not understand, and now we are realizing it what was happening. Sorry, slightly off the track, but since Rajan Bhai, you had brought out the issues of IP, maybe it was by
No,
design,
Devansha,
and maybe every one
Devansha,
of us is facing that.
yes, sir. No doubt about it. And especially if you're a new RP, it's fine because you haven't faced the wrath of uh, COC yet. But people who have faced the wrath of COC, they know that how can you have absolute powers with no responsibility? So obviously we know this, sir, what is happening. Uh, to coming to your one point, sir, when you said OC should also be given a chance, uh, please try dealing with a real estate CIRP and then your view will change.
Sir, I'm
Because,
dealing with a couple of real estate CRPs. I'm talking of the global position, and
sir,
maybe it
sir, our country is a very litigating country. Everybody
yes,
will reach to IA by paying 1,000 rupees in NCLT. So,
yes,
that is a problem. And that is why if you'll put every OC also in the COC, sir, it will never run. Right now, also, one RP is there and he's fighting with COC promoters. I can say NCLT also. Try coming to principal bench, sir, someday, and you will know what I'm saying. Try coming to Amaravati bench and you will know these days. So the moment, I mean, but that is a life we have chosen, sir. Right now, we have to agree on one point. This is a law. This is law of the land for the time being. Whether it's fair, not fair, we have chosen it. We have to work within
absolutely,
these boundaries, right? So,
yes,
and today what we are doing is we are trying to learn some nuances that fine, this is law of the land. Right now it states as so and so, and let's try to be, you know, obviously there are firings, right? So we only have to put our shield. We are trying to learn some more
absolutely.
tricks and tricks. That's all, sir. Problems we are
Very
all aware,
positive
sir.
way, very
Devang,
positive. Very
Okay,
positive way, sir. Thank you.
thank you. Okay, so with this, I guess let's take some break of 15 minutes, 10, 15 minutes, and then we'll have 1 hour to go. Yeah, 6 o'clock, right? So 10 minutes break, and we'll come back with uh, one very interesting High Court decision is gonna come after 15 minutes, right? So I'll catch you. Miss Anjali, is it okay if we take a break, please? I don't know if she's here.
Yes, sir.
Okay, so we'll take a 10-minute break and come assemble back. Okay. And others people please join, like two people have now starting talking. Let's talk out, let's vent out something here, okay? See you. I'm putting it off for the timing. 10 minutes. Can we start now? Amit sir. Amit sir, you can hear me? Talwar sir.
Hi, sir. How are you?
Yes, sir.
Good.
Welcome
Sir.
back, sir.
Thank you, Ji. Thank you. Ji, join kare. Okay, so let us start our one more hour for today. Guess all of us are here. So today I spoke only to Devangji and Rajan sir. Nobody else. Huh? Tell them. Sir, as an IP, no, at times we love to talk, right? And as an advocate also. So I request दो चार लोग और, if you would like to share any interesting, see, there are hundreds of cases which are decided every day. At times it's very difficult to pick and choose, right? But if you have something interesting, please do feel free to share, as Devangji was sharing, or in fact, Rajanji has shared a pretty decent thing where one bench of NCLT approves your plan and second bench says, no, how can you do this, right? So, and Rajanji, in that, Rajanji, you are here, you're back.
I'm there, sir. Yes.
So, you said that in NCLT it's still pending, right?
Yes, sir. It's still to be adjudicated.
Still to be okay. So,
Sir, one more
so we
point.
don't know
Since
who's correct, right?
Since you raised this, so NCLAT in its first hearing in the appeal, it passed an order stating that there is no stay on the implementation of the plan, but it shall be subject to the outcome of the appeal, right? So now,
Correct.
so basically NCLAT says that there is no stay on the implementation, but it will be subject to outcome of the appeal. Now, the NCLT at the local level, second bench took a view that there is no stay on the plan, therefore the plan should have been necessarily been executed. But if you read the order of the NCLAT very properly, it only says
so this is principal bench, right?
Principal bench.
I don't know which one, but see, I could guess it, right?
Yes, sir. Yes,
So
sir.
that is one bench where we are
These
getting
are
such
standard orders
right?
that are being passed, sir.
Arre, sir.
Yes, standard
I know.
orders. Yes.
I know, sir. So, and at times I feel, at times they are not, they confuses COC and the RP. And after 8 years of practice, I went to NCLAT. I said, please explain me what does this order means. They said, have you come here for the first time? You don't know what is IBC saying. Read the law. So they will stay the process, but they will say, run the process as per CIRP. If it is stayed, then do you listen to promoters or you listen to COC? Whom do you listen to?
Of course, the COC.
No, how is it of course the COC? If they are saying run the CIRP with the assistance of promoters.
So assistance I will take if they are giving, sir.
And who will give the money?
Sorry?
Money approval, who will give?
So at the end of the day, money and approval that has to come from the basically firstly from the operations of the company, if operations of the company are not there, and if promoter has any ideas.
Good. You said if operation is there, then no need of COC approval.
No, I am not saying that. I am COC approval is 100% required. I am saying
Sir,
the source of money.
why will they do it? They will say you are running it with the help of erstwhile management. They are chores, they are thieves. Why should we approve it? You did not take our consent.
No.
Then
COC
what?
consent has to be taken. There is no doubt on that, sir.
So if you take COC consent, you are flaunting NCLAT order, which said take their assistance and do it. So which one will you follow?
No, sir. So basically, if the operations have to be run, they have to be run only after consent from the COC, and if and with the, if you decide to run the operations, then the help of the promoters has to be taken, necessarily to be taken. Sir, I tell you, if the COC has an apprehension that the promoters are chore, right, which they generally are. So
Yeah.
if the COC has that apprehension, then they have the buffer of the RP. No, sir, now the RP is in control of the things. It's just that for technical matters, probably he is taking the assistance of the promoters. Promoters can.
Oh, okay. So you are saying only for technical thing you
So
take their assist.
so
So
where
you are
I.
reading into the order, right?
Hmm.
So what you are essentially doing, you are reading into NCLAT order, correct? Which will be challenged by the promoter in higher court saying NCLAT is not listening to you. Sir, अभी तो पढ़ा था आपने. You said no, proviso is very clear.
So
When
yes,
it is so clear.
so basically, what is important is to take their assistance in running the company. That does not necessarily mean whatever they are saying will be followed by the others. Just that he has to involve them in the process. I am doing this. If you have to say anything, kindly let me know what you have to say on this. Let us sit, discuss, and we can accordingly plan.
Sir, you are talking about positive things. Unluckily, you know, where we work, the kind of thing, they are always on the opposite side.
They are always on the opposite. You are right, sir.
So it's not, you try sitting in the CD's office for 1 month.
Mm-hmm.
Next month, COC will say कि लाला जी ने खरीद लिया है. So, those issues you also must have learned. We are all learning, sir. And you don't sit in the COC office, you don't know वो पीछे से क्या कर देंगे. How will you run the CD as a going concern and maintaining the value? So, I mean, those issues are there, will always remain there, sir. So, and sir, आपका कभी आएगा, we'll certainly discuss what happened, because uh, this case which you were saying, I think it's a very interesting case where if it was wrong, why the erstwhile NCLT approved it? So they also have
And
some
erstwhile NCLT
responsibility
has passed
somewhere.
a speaking order that it has been informed to us that the plan has not been implemented because there is a challenge to the plan. So they have, basically it's a speaking order by the erstwhile NCLT.
And still you have been called for doing some things which, yes, sir, that is our, okay. So we had left the practical takeaways from this case, which was Independent Sugar Corporation, that's CCI. So practical takeaways in my view are, if your plan triggers a Section 5 combination, file and obtain CCI approval, that is green channel form 1, form 2, before the COC vote. This is ultra clear as on today. RFRP drafting, make prior CCI a condition precedent to COC consideration. Align bidder undertaking and RP process emails to the sequence. Challenge strategy. And unsuccessful RA has locus to a sale COC approval where the statutory sequence was not. So if you are advocates here, it actually opens up a Pandora where, let's say, if I cannot go to 61, I can go to 62. If NCLAT doesn't listen to me, Supreme Court will listen to me, and I will say the statutory sequence was not followed. So this is creating litigation. If you're not litigating mind, don't read it. Policy backdrop. The ruling has prompted debate and even proposed legislative change to shift CCI clearance to post-COC. So if not post-COC, prior to NCLT approval, I think can be done, or at least post-COC can be done. Because see, even in COC takes months at times to pass. It's not that in first meeting only they are passing it. In fact, one of the recent order, I don't think it's here today. It says RP can only negotiate with the PRA once. Correct? You can only give it back once. But COC can do it any number of times. I think 2-3 days back, this decision was there. RP can only return it once to get it corrected, etc., right? Make it compliant. COC can do any number of times. No limit on that. So COC commercial wisdom is like a superpower which is without any answerability, sir. So I guess all of us have lived that. Okay, apart from that, sir, let's go to one case which is a pretty famous case, Baiju's Ravindran, Glass Trust. Uh, I hope all of us are aware, but in case not, why this is important? Okay, I know it's a little old case, but old case in the sense almost 10 months. This is important because there are many cases which get settled, right? 12A. In fact, I have settled 3 cases under 12A in my CIR, right? So this Baiju Ravindra case was pretty unambiguous, pretty clear. They said nothing doing, 12A has to be followed. No ifs and buts. Apart from which NCLT said, right, in the first case which we had discussed, right? That reverse CIRP where said nothing is left and nothing.
Yellow.
तो उदय जी साइलेंट कर लीजिए हो सके तो। उदय गुप्ता जी म्यूट कर लीजिएगा प्लीज। ओके, so Glass Trust, Baiju Ravinder was a simple case. BCCI was involved. Think and Learn Private Limited. They faced a Section 9 petition from BCCI. NCLT admitted the petition. Obviously, moratorium comments and such. After the commencement, they did a private setup before COC, right? This was a normal situation which was happening. We have filed 12. I have filed 12 within 2 days also, 1 month also, and I have filed a 12 after liquidation application was filed. Even though those kind of, I mean, when we were about to file the liquidation. So though anywhere and everywhere we were filing 12. In this case, what happened is private settlement negotiated before the COC was formed. Baiju promoter entered into a bilateral settlement with BCCI to pay 158, and I think they paid also. This settlement did not involve other potential creditors, right? And obviously, formal 12-way process not followed. They went straight away to NCLT. NCLT said, fine, if nothing is, remaining, it's clear. And so actually, they went to NCLAT. And NCLAT, especially principal bench, has this panchayat kind of settings where they say, okay, whatever is saying, we'll do it. Which is at times, in the interest of justice, it's fine. When you use that inherent power to meet the interest of justice is fine. But when every time it happens, then what happens? Then you don't know what is final, correct? Then there is no law. Then it is whims and fancies. So to air NCLAT intervened via Rule 11. Rule 11 is for both, right? NCLT as well as NCLA2. Here, settlement was placed before NCLAT. They invoked their rule. They said they allowed the CIRP to be withdrawn without a 12-way. COC constitution approval, nothing, no need of this. And NCLT also was not involved. They said, fine, we are closing it here and then and there. Story is over. Now, Glass Trust went in appeal. Glass Trust was the operational creditor. They were challenging that, we are made OC, we should be FC, etc. All those things are going on. Glass Trust represented overseas financial creditors. They challenged the NCLAT ruling, arguing 11 is procedural and cannot override the substantive framework. In the sense, they said rule should not overrule the code. Section is here, rules and regulations are lower. How can a rule is overturning a clear statutory provision of 12A? And why they were aggrieved? Because they said once it is a process in RAM, then how come only one person is being settled? Everybody else should be settled. So these are the facts, bypassing statutory process, depriving other creditors of the right. CIRP, once admitted, is a collective proceeding or proceeding in RAM, and hence private settlement between CD and the creditor, even if that creditor is a applicant in the main application, even then it is not allowed. So rule 11 is what? Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the appellate tribunal to make such orders as may be necessary for meeting the ends of justice or to prevent abuse of the process. So this was supposed to be sparingly used rule. Judicial position before this case was NCLT, NCLAT had previously used Rule 11 in limited situation, mainly to recall orders, condone minor delays or defects, and issue interim procedural directions. However, some benches had controversially allowed CIRP withdrawal via Rule 11, especially before constituting COC. Right? So this was a normal. So right, in 12A there are 4 stages. Right? Prior to issuance of publication, then you have publication, then COC formation, then after COC formation, right? All that, or before resolution plan. Now, so fourth one is before resolution plan. Here, Supreme Court very clearly said, Rule 11 cannot be used to bypass a specific statutory mechanism. So if somewhere, I think why this case is important. So if there is statutory provision which is so clear, do not file under Rule 11, and if somebody is getting any relief under Rule 11, it is very well challengeable. Section 12A plus Regulation 30A provides a complete code for withdrawal. Inherent powers are always subordinate to substantive. See, Supreme Court inherent power is something different, right? 143. No challenge. But tribunals, they don't want to leave this power. They are saying tribunals, boss, just follow. You are creation of parliament, follow the parliament. These tribunals are not creation of our constitution. Constitutional courts are, they consider themselves fair, and tribunals have to follow what the legislature is saying. So inherent powers are always subordinate to substantive law, and I think it's an important decision for not only for 12A, but for anything else. If it is clearly in sections, don't try to take a side route. If you take side route, there is fair chance you can get it challenged at the top level. So I think issues we have already discussed in talks. Can NCLAT use its Rule 11 post admission? Does a bilateral agreement, survive? Can they just ignore collective nature? And should fund from a settlement be treated when other creditors exist? Because the challenge was where this money is coming from. This 158 crore is going to whom? To one person. Can this one person not be treated as a preferential transaction? If suppose CIRP happens after 6 months, suppose, right? Because it's withdrawal. You cannot have a CIRP within 12 months if it was a CIRP, but this is a withdrawal CIRP, right? Will this not be considered a preferential transaction sometime? Because you are giving to one operational creditor.
Sir, in my humble opinion, no, because it is as per a court orders.
Correct. And that is why it was overturned. Right, sir? What you're saying is right. And that is why, because it will open up Pandora, it might. So they said, no, first do 12A, only under 12A and regulation 30A comes. Otherwise, don't use rule 11 for everything and anything. So decision, rule 11 cannot override section 12A. Inherent powers cannot be exercised in a manner inconsistent with or in direct contravention of the substantive provision. And I think 12A, you are aware, application by RP, 90% COC approval, NCLT sanction is required. And it is filed by the applicant. Applicant gives form FA, right? Skipping these steps undermine procedural safeguards and creditors' dominance. Also, I have heard cases where FA was given without bank guarantee or without making payment for CIRP cost. Can you accept it?
No, sir.
No. So that should not have been done. If somebody wants to challenge it, let them go and challenge. But section is very clear. It has to be with bank guarantee or let's say check or transfer to the account or whatever, but not without that. So CRP, collective process, once it starts, petitioner is immaterial, COC is servopari. Again, COC is supreme, right? So what are the decision? Settlement money to be held in escrow, 158 crore, that whatever the amount was, it should be transferred to the escrow and it should be, and I think this was again challenge, etc., is going on. I don't know if anyone is aware of what is the current status of Byju's. Even have not checked it recently. So if I don't know if they have challenged it or not. So if they have challenged it, we'll see. In my view, I don't think they have challenged or it's under consideration.
Sir,
And
I have a
future,
question. I have a question here, sir. With your
yes,
permission.
yes,
Okay, actually two, not one. So, section 30A2 says the application shall be
that
accompanied.
is regulation, sir.
No, I'm on regulation 30A. It says that the application shall be accompanied, shall be in form FA and accompanied by a bank guarantee. Right.
Correct.
Now, if we see the form FA, it says I attach. So basically, it is signed by the applicant. Right. The
Correct.
applicant means the petitioner, we can say. So
Correct.
I attach the required bank guarantee as per sub-regulation 2 of regulation 30A. Now, basically, the applicant is signing the form and he is saying that I am attaching here with the bank guarantee, right?
Correct.
How can the applicant get the bank guarantee for the CD, sir?
So you think there is a flaw there?
On the face of it, yes. I mean, how can the
It's been 8 years, sir.
why should the applicant organize for a bank guarantee? And how can he get it on behalf of the
On behalf of?
CD? At the end of the day,
No, he is not giving on behalf of CD.
no.
Who said he is giving on?
No, see, bank guarantee has to be given by, see, as per the law on the subject that we are reading, it is for the
Yes,
applicant
yes,
to give.
yes.
Applicant,
Yes, yes,
right?
yes,
Now,
yes, yes.
basically, at the end of the day, it is for the CD ultimately because the CD is going to come out of the clutches of CIRP. So
Correct,
the CD
correct.
has to pay all the expenses that have been incurred, right? At the end of the day. So
Correct.
I'm trying to understand how can it be that the applicant is organizing a bank guarantee? My very limited point on that.
Oh, no, very good question. And let me give it to the forum itself. Anybody would like to answer this question?
I believe, sir, applicant is the applicant of that particular application, not the applicant of the main petition.
No, sir. And then anybody can go, right? Okay. So he is throwing some new thing. He's saying let that applicant be considered Even CD can be an applicant, even
Yes,
anybody
yes,
can. That's what
yes,
you're
yes.
saying.
They are mutually agreeing to the. They are coming to the common ground and they are settling between both of them.
Sir,
This is the thing.
Form FA is signed by whom?
Sir,
Anybody can sign.
Form AP starts with name of the applicant, had filed an application bearing particulars of the application, diary number, before adjudicating authority under section 7(9). It is nothing. So form,
Okay, so it is the main
it is the
petition applicant.
petitioner only.
Who started the, who started? So
Okay.
Petitioner,
be it section 9,
7,
anyone.
whatever it may be.
So law is clear, sir. कि यहाँ पे at least the person who actually made effort to get it in CIRP will at least be settled. So only that person can withdraw, nobody else. COC में तो 100 लोग हो सकते हैं सर. ऐसा नहीं है anybody can file. No, only person who had initiated. Because see, उसने 2 लाख रुपए भी दिए होंगे, right? 2 lakh, 5 lakh, whatever, right? So, and this person had made efforts, made, the law says 7 days and 14 days, but you know, he must have spent 2 years. He must have spent on lawyers. So that person has the right. Good question of Rajan ji is why this person should say. But sir, where it says that that person has to give his own bank guarantee.
So he says, I attach the bank guarantee.
हाँ तो
So
उससे
who,
लेके दे दे सीडी से, क्या प्रॉब्लम है?
so who organizes the bank guarantee?
सर जिसको बाहर निकलना है. सो बर्डन ऑफ प्रूफ हमारे लॉ में क्या होता है? बर्डन ऑफ द प्रूफ इज ऑन बेनिफिशियरी.
Sir, I have a different point, sir. When the
Yes.
CD is admitted to CIRP, and once the
Yes.
CIRP has
Yes.
started, the funds of
Yes.
the CD cannot be
Yes.
used
Yes.
for withdrawal purposes, sir.
Absolutely right, sir. So CIRP fund cannot be used for this.
So at the end of the day, it has to be the suspended director who organizes the
Absolutely.
funds. His
Or
own
the
funds to be
promoters.
paid to the
Correct.
applicant, and he organizes for the bank guarantee also, and the applicant is only attaching that bank guarantee to the FA form, sir.
Absolutely, sir. Yes.
This is probably what we can devise out of.
No, that's what is happening, sir. And in, as I said, in the matters which I have withdrawn. See, bank guarantee comes if it is after, say, 9 months, 1 year, you are withdrawing, then the bank guarantee, because bank guarantee, the cost is only how much? 1%, 2% for 1 year, correct? If it is fund based. So they might have some fund base, they will give a guarantee. They said, fine, if it is getting withdrawn, I am ready to put them. But if it is done within 1 month, 2 months, we really get into bankrupt, this guarantee. I don't.
You
I
will just
ask
pay
them to
off.
put, you simply pay that much money, give a check, fine, get it over.
So if you make a statement before the bench that no CIRP expenses are pending, and the IRP also makes a statement that I have received my fees, then at that point of time, the bench will not ask for bank guarantee. There is no reason.
Certainly not. Certainly not, sir. See,
There is
bank
no-
guarantee is to ensure that we will get that. But if you have already got it, then what is the problem? There's no problem. Bank guarantee is just to ensure that RP is not left hanging.
Sir, I have
And
one
that
more
is-
question, sir, in this, sir.
Yes.
Sir, now what is happening is that CIRP going on, the suspended director has offered full payment to all the claimants. Full payment. He says, I want to come out of the CIRP. I am offering full payment, right? Now, so to give the correct picture, some time has passed, sir, a year or 2, 3 years have passed in the CIRP, where there has been litigation between the petitioner and the suspended directors. Subsequently, finally, the subsequent suspended director feels that enough of litigation, I want to settle this matter. He is offering in writing to all the claimants that I am paying you 100% in full, right? Now, the applicant, the petitioner, Section 9 petitioner, he says that I am not willing to accept this amount. I want 3 times the amount, and therefore I am not giving you the Form FA. Can this be done?
Sir, if his admitted claim,
Admitted claim is giving full, sir.
sir, admitted claim, if full thing is done, is paid, you have 1160/5, you can file it. Nobody says no to it, sir. It's not an arm twisting mechanism, right? Go to NCLT, say every full money is being paid. Still, if this person is
No, it's not being
stopping
paid,
it.
sir. We have offered to pay. We say that you give us the Form
No,
FA.
sir.
We are-
Offer to pay,
No,
offer
we
to
are
pay
willing.
has
So
no
we
meaning.
are willing to deposit that amount in NCLT. We are willing to
Hmm.
deposit that amount.
Then
We
what
are
is the
not-
problem, sir? Then no need of Form FA from that person. Sir, then seriously you can go for it, no problem. Suppose that person is no more and abscond. Suppose let us think that way. That applicant is no more, died. Now what will happen? Can you file 12A or not? You can, no. Your situation is different. Then that is why we say every case is separate. Here, this person is giving full money, correct? Another option can be let this promoter give that much money to RP account, to your CRP account. Say, I am putting his money, this is his money, or whatever you call it, escrow, etc. His money. Now I'm giving Form FA. We have subrogation, right?
Yes.
Subrogation is what? Your money, I have paid it, now it is my money. Now it is my asset. So if he's ready and willing, no problem. Only problem is, sir, promoters, they only give vade. That is the problem. But if it is 2-3 years and some interest he thinks would have accumulated, etc., etc. I mean, that's again a matter of negotiation, I guess. But it can be done, sir.
So
In my view,
can the
yes.
NCLT decline such a petition? Such a IA?
In my view, no, sir. In my view, no.
Okay.
See, the code never said. Look at the preamble. If they try to decline, show them the preamble. It is to resolve insolvency. Insolvency is resolved. He is offering 100% to everyone. Till now, you could not do resolution. If you would have done within 6 months, it's fine. No. Now, if time has lapsed, maybe his situation has improved. He wants to get out of it. What's wrong in that? And he's paying everyone. So at that time, use preamble, sir. And again, sir, there is never a right and wrong answer. It's always on your advocate and how you are presenting your case to the
It is always got the bench feel it to be true, sir. Correct.
But I think it's worth a try. If anything is getting resolved, it should always be resolved. Okay. So Byju's was that procedural and substantive. So this is what they were discussing. This cannot override. This I think we have learned already. Now, I don't know if Ranjanji is here today or not. No, he's not here. Okay, so this is a matter where not Rajanji, it was Rajiv Ranjanji, sir. I was looking. Okay. I'll tell you why, because he was the liquidator in this case. So Anshul Gupta ji, liquidator of Tops Group Services and Solutions Limited. It's a 8th July order. Now, in this case, what happened is, this was between Indian Bank and the liquidator. CIRP commencement. CIRP was initiated against Tops Group Services and Solutions by an order of NCLT. RP, who later become liquidator, opened a designated CIRP account with Yes Bank. So Yes Bank has the liquidation account or CIRP account, you can say, right? Now, refund in question, there was a refund which is from Income Tax Department. During the moratorium, Income Tax Department credited an income tax refund of 4.5 crore to the CD's pre-CIRP account. Fine. With the Indian Bank. Indian Bank was old bank. In their own account, it was credited. Obviously, they have one, how you file your returns, right? You give a bank account and that income tax credit comes, right? His life is good. Now, instead of transferring the sum to the Yes Bank, Indian Bank retained the amount. अब आप बताओ, after 8 years, anyone thinks it's correct position of bank? Can they retain this amount?
No way, sir.
You are saying no way, okay? And anybody else has another view? No view, right? So ideally there cannot be another view, right? Now let us look at this. Bank justification. Indian Bank claimed that it had a valid and enforceable security interest over the CD under, deed of hypothecation, right? Bank argued that the refund constituted a receivables and thus fell within the hypothecated assets, entitling it to adjust the amount towards the outstanding dues, towards its dues. A liquidator is saying the refund arose after the commencement of CIRP. So it is assets, our asset, and during moratorium, it will be ours. Otherwise, it is liquidation asset. Correct? Section 14, right? Moratorium, it prohibits any appropriation or recovery. No problem. All RPs or liquidator would have said the same thing. Now, bank was bound to transfer this to CIRP. Now, what happens is whether a bank holding a security interest under hypothecation is entitled to retain an income tax refund or not. Right? Simple. Decision is, and this is not NCLT, this is NCLAT. Effect of moratorium, we all know what it is, right? NCLAT observed that security interests are suspended during moratorium. No secured creditor can unilaterally adjust or set off amounts received after CIRP commencement. Decision came, income tax refund as an asset of the CD. Tribunal held the refund is a fresh accrual post commencement and thus falls securely with section 18F. That means asset on which IRP has the control. Even if it is covered with hypothecation, it cannot be appropriated. Fine. Now, decision, the bank, function of the bank maintaining the account of CD during the CIRP is akin to only that of a custodian. It's not at liberty to unilaterally deal with any amount credited, whether by way of refund, remittance, or otherwise, and must strictly work under the instructions of RP. So obviously, till here the decision has no problem. Banks are only facilitator of CIRP, not claimants outside. So NCLAT is clear on this, right? All of you are clear? And this order came in 8th July. And the order was very clear that within 15 days, they have to give it to the liquidator. And 15 days was 23rd of July. So till today, I was talking to him in the afternoon. This money has not come. And that to Indian Bank. Flouting NCLAT order straight away. Now, I don't know whether they'll go into contempt or Indian Bank will go into appeal. We are not aware because there is 4.65 crores So they will also appoint a senior lawyer and try to delay it whatever possible time. So just a recent order, that is why I thought I'll discuss. I don't know whether it's really important or not, but for your information, any refund, no adjustment can be done. All banks have to work under the RP or liquidators instructions. So this was
Sir,
Indian Bank versus Anshul.
unfortunately, in such cases, what happens is once the IP files a case of contempt, etc., or says notice, etc., the IP is blacklisted by the
Uh,
bank
I
and
know,
arm
sir. I
twisting
know.
begins. And it's the biggest and the best of banks, so-called best of banks, so-called. Even they have done that. They have pushed the IPs into B list and C list and stopped giving cases. So these are the unfortunate things that happen in IBC.
I know, sir. At times we are at the mercy of that empanelment. Uh, but
Absolutely,
as
sir,
we were saying,
absolutely.
we have chosen to be in this field, sir. Uh, can't
Yes,
help.
yes,
I
yes, we
mean,
have chosen, and maybe we
and
are. It was
at
not the right decision. We are not given the right picture, I would say. Anyway, now we
uh,
understand, and we are. It's our choice whether to continue with it or leave it.
correct, sir. Correct. No, and see, obviously COCs are taking their own sweet time. No, I mean, you know how much time they take to decide one NRRA. I mean, we have dealing with one NRRA for 4 years now. So if it is, it was not readily realizable. That is why it has come to you. You have to say yes or no. Now,
So
especially,
in one of my cases, I was requested by institution to take case on pro bono basis. It would take a very short period of time because there was hardly any assets. I took
yep,
case on pro bono basis.
they always say that,
Unfortunately,
sir.
it was the wrong decision on my behalf. It was my decision, so I have to pay the price. Now I don't get cases of lakhs of rupees per month because I'm handling cases. This case is on my name. So I lose PSU cases of few hundreds and thousands of crores. Now this institution turns it back, doesn't take NRRA, doesn't take decisions, and wants me to be stuck with the case permanently until the case is disposed by Supreme Court. This is the unfortunate thing which is happening. And I tell all my fellow IPs, don't take any case on pro bono basis for financial institutions and banks. They are not poor guys. Those who deserve, we will take for poor people. But they don't
Absolutely.
deserve this. They are rich. They pay hundreds of crores of rupees to some consultants and lawyers. They have that money. Let them pay the price. We should not take anything. We should charge them through their nose.
We are with Devangji. Certainly, sir. I hope everybody is with Devangji. What he's saying is right. Uh, Unluckily, sir, people don't have cases. They only do such things. Let's try to maintain some dignity in IRP profession and not go for 15, 20,000. My bankruptcy fees is 2 lakh plus per month. So, and even in PG cases, it's 1.25. So I also try not to, take, if it is a throwaway thing, then let them throw it away. Why do they have to process it? And if they have to give it to newcomer who is actually doesn't have and needs a case only for the namesake. So as seasoned IP, I think you can avoid that, sir. Uh, I agree with Devangji. So this is eighth case. This is a Madras High Court case. 4th August. That means today is what? 8, 12th, right? 11, 12, 11. So 1 week back. Now in this case, Anil Kumar Ojha, the and versus the state represented by IG, CBI, etc. What happens in this case is, I mean, just the decision has come.
Well, sir,
Hiji, you are saying something? Or? Okay. So background is petitioner Mr. Ojha, former MD of SLO Industries, triggered section 7 CIRP against his company. So liquidation report. So obviously that CIRP, etc., we can forget. Liquidation report is RP after takeover discovered massive discrepancies in the inventory. Very standard case, correct? Rupees 840 could not be reconciled. Liquidation. Now, NCLT found a stock shortfall of 625 crores as per the RP report. Fine. This. Okay. So CBI or Anti-Corruption Bureau investigation, it says court directed preliminary inquiry into the irregularities outlined by the RP. CBI ACB registered FIR. However, a final report was pending due to non-grant of sanction required to prosecute a public servant under POCA. This is POCA actually, Prevention of Corruption. Delay in sanction. IBBI as a statutory body was sought for sanction. Their delay was attributed to pending litigation at Supreme Court, particularly Delhi High Court ruling in Dr. Arun Mohan, that case which was here. RP are not public servant, correct? This was the order, and this order is under appeal, correct? Now what happens is, IBBI did not give that permission. Issue is a RP public servant under POCA? And if yes, sanction. And see, whenever, when you are reading it, always read it like that. Whenever they say if yes, this, then you know that half of the mind is already ready, that answer has to be yes. If yes, sanction under 17A1A of POCA is mandatory before prosecution or not. So Delhi had said what? No, they are not. So we said, okay, no problem. But obviously it's under challenge. If it is under challenge, that means it is not valid. Here, decision is RP performs duties connected to administration of justice. Court rejected the application of so and so as relied upon by another high court. It held RP is authorized by a court of justice to perform duties in connection with the administration of justice, that may thereby fulfilling the threshold under Section 2CV. RP provides reports called for by judicial or public authority, which is Section 2C of POCA. RP reports are routinely submitted to NCLT and to other authorities whenever aligning with any person to whom a matter has been referred for report by a court of justice or by a competent public authority. That means RP discharges a public duty. Although the RP operates within a commercial framework under the COC, court held that fulfilling duties, including forensic accounting, asset management, public sector oversight, is undeniably a public duty. Precedent alignment, court referred to Swiss Ribbon, ArcelorMittal, SR Steel to recognize that RP's administrative role, yet concluded that this does not exclude them from being a public servant. Now, Devangji, what do you say? One of the oldest court of India, that is Madras High Court, calls you as public servant under POCA. So if you are under POCA, then obviously big trouble is also there, right? A person who is public servant without getting money for many years also, right? So which public servant doesn't get monthly salary? I don't know.
So the biggest problem in public servant is that even if there is no misappropriation by the IP, but there is a feeling it's a misappropriation, yet the problems begin. It's just the
Yes.
feeling that something is wrong is enough to create issues where we don't have any protection. And we are having the decisions are taken by someone else, and the responsibilities are cast on us. Either give us both the authority and the responsibility, or those who are having the authority, let them be responsible. They are coolly getting away from their responsibility, and unfortunately, we are being used as the scapegoat, and all the responsibilities are being cast upon us. This is unfortunate thing, and I firmly believe this is not by accident. This is by clear design by few people. And unfortunately, so I clearly say at every forum possible that those who sit in IBC committees, who are they? Is there anyone from industry? No. There is no one from small industry. There is no one from mid industry. There is no one from large industry. There is no financial expert. There is no practicing insolvency professional. There is
Devangji,
no
Devangji,
turnaround professional. There are
Devangji,
only select few laws and bureaucrats. Even the entire legal fraternity is not being represented over there. So the practicing
Devangji,
professionals are not even over there in the committee, in my understanding. This is the
Devang Bhai,
problem.
Devangji, Suni. Sir, unluckily, this is not a forum. Neither you can do anything about it, neither I can do.
Yes,
What we
yes,
can
yes.
only do is, we can learn these 9 cases today. Learn how can we save ourselves to a little
Absolutely.
better extent. Correct. Now, I do understand. You are CA, sir, Devang sir, or
Yes.
yes, you are CA, right? So I don't know many CAs who have dealt with Inspector General of Police, CBI, ACB, anti-corruption. Half of Indians will, run away from the work. Being an advocate, it's okay. We deal with police and CBI, anti-corruption, it's fine. For especially for professionals who come from, CA, CA, MBA background, it's a pretty tough situation. And I have no quarrel with you on this decision, sir. Yes, one high court is saying they are not, another high court is saying they are. Now, Supreme Court has to decide whether we are public servant or we are not public servant. So this is a case, very recent case, 1 week back, Madras High Court, Anil Kumar Oja. And with this, I come to my last case of the day, which is HDFC Bank versus HEMA Engineering. HEMA is a famous name right now. Okay, so this is a NCLAT order, 5th of August. Again, 5-6 days back, this has come. In this, what has happened? HDFC Bank versus HEMA Engineering. Liquidation was ordered. NCLT commenced the liquidation proceedings against so and so company, appointed liquidator. Now, HDFC was a secured creditor. They chose to realize its security interest outside the liquidation estate, right? That is possible. 52. Bank delayed its communication that they want to do it outside 90 days. So within 90 days, they failed to tell the liquidator that we are realizing the assets outside. Fine. And obviously in Supreme Court also they have held that no, it has to be communicated properly. Somebody wants to realize security interest outside, within 90 days, you have to inform the RP. Still HDFC went to appeal. HDFC says, a reason for delay they gave, they said the delay was due to issues beyond its control, such as they could not identify the secured asset. There was third party encumbrance. There are other procedural bottlenecks. And timeline should start from the date of such identification and not from LCD, which is liquidation commencement. Here, liquidator said, no, sorry, regulation is mandatory. Timeline starts from LCD, you have to give. NCLT order said, NCLT upheld liquidator's interpretation, saying HDFC application was time barred under regulations of NCLT. Because 90 days they did not tell. The issue is whether 90-day period for a secured creditor to intimate is when does it start? Whether it starts from liquidation commencement or from property identity. And what is the answer? I hope all of us know. It is LCD, right? Now,
Yes,
interpretation
it
is
is
given.
LCD only.
Correct, Mariji. Where a secured creditor opts to realize its security interest, it shall intimate the liquidator of the price at which it proposed to realize within 90 days from the liquidation. In fact, they have to tell the price also, not like we can do sell at whatever. Because if liquidator says I can do it better, they'll come to you. NCLAT reading, provision is clear, unambiguous, 90-day clock begins from LCD. Statutory scheme cannot envisage the shifting of commencement date to a later stage. So mandatory nature is there. It is mandatory, not directory. Now, I don't know why lawyers suggest even such kind of things to different banks. But that's that. I think in between we had said that we are litigating country, so we love to create issues. This is one such issue where unnecessarily they said no, we want to execute outside because we don't want to get in the bus. As an liquidator, you take your stand. And with this, okay, they only said exceptional circumstances. Obviously, they still left it and NCLT discretion. They said if the delay is not attributable to the secured creditor, the creditor may approach NCLT for extension of 90 days or exclusion of a specific period. Such relief may be sought before expiry of 90 days or with conviction justifying it. So again, if you see, they said, okay, in this case, no, there is no justified reason. But if somebody has justified reason, they can do that. They can still go to after 90. So before 90 on 85th day, go there, please. I cannot do it. Please allow me 30 days more. They can allow. So since they failed to show any of these, they said no, it has to be upheld. So I guess with this, my PPT is over. If any other comments we have, Rajan ji or Mahesh ji was there today.
Sir, can you share the PPT?
Oh yes, I'll be sharing with ICSI also. And
Let them send the same to us on our email. That will be quite helpful.
yes, sir, we will. I hope you got it. If you want just a very short recap, today we did Kalyani Transco, where Kalyani Transco is our Bhushan Power, right? It is under challenge. So
Yes.
plan was quashed, liquidation was ordered after 5 years. Then we
The
had learned
Bhushan
with
Power
reverse
judgment today
CIRP
is reserved for
process.
order. The Bhushan Power judgment today is reserved for order. The order should be coming sometime.
Sir, as on today, sir, it is not
Yeah.
reserved. I know today it was reserved. So whenever sir, one of my Supreme Court matter reserved 1.5 year back. Don't know when it will come, but luckily in Bhushan still they will follow it up and it will come. So second case we discussed was Grand Realty Satish Chandra Verma, which was reverse CIRP, where if nothing else is pending, it can be settled even without 12A, even without byju's. That's what NCLAT tried. In Sincere Securities and Chandrakant Khemta, we learned that voluntary surrender can be done of the assets and section 14 will not stop it. COC can take a decision. Fine. Then Electro-Steel Ispat, we learned that arbitration award, whether after that it can be enforced or not, and our arbitration section 34, it should have been challenged, not challenged, that we learned, where High Court decision was overturned by Supreme Court. In line with Ghanshyam Mishra, right? Then we learned independent sugar case, independent sugar corporation, where CCI approval is mandatory as of today, it stands that before the voting happens, it should be in place. Otherwise, they will not have. And this makes unsuccessful RA also as some locus. After that, we had Baiju's thing, which is 12A, at what stage it should be done, and 12A has to be followed. Rule 11 cannot overrule it, right? After that, we learned Anshul Gupta and Indian Bank case, where they retained the refund of income tax, which was ordered to be given, but is still not given as on date. Then Madras High Court order we learned just now, where Delhi High Court said we are not public servant. Madras High Court said we are, and this decision is under challenge at Supreme Court. And after that, last one, just now, HDFC Bank, he said 90 days clock starts from LCD and not from any other day. That is the pickup for today. Tomorrow, 3 to 6, I think we'll try to get some PIRP cases. And if you have your own experience, please do share. Tomorrow, I hope you'll share more. And I think we can close this for the day today. Anjali ji.
Yes, sir. Thank you very much, sir, for nice session and for sharing your valuable knowledge with the participants. Thank you very much, sir.
Okay, ji. Good
See you
night.
tomorrow.
Good evening, everyone.
We carry out with a loud applause.
Thank you, Rajendra. This was
Thank you, sir.
Devvart Rana.
Great, sir. It was
And
fantastic
Thank you, sir. Thank you so much.
session, sir. Thank you very much.
good day.
Thank you so much.